that of Her Royal Highness the Duchess of Sussex and Associated Newspapers Ltd.
Mr. Rushbrook, we will observe 2 minutes silence at 11 o'clock. I believe it may come over the intercom. If it doesn't, we'll still observe 2 minutes silence at 11 o'clock.
Lord, Lady, since yesterday's adjournment, my learned junior, ever eagle-eyed, has reminded me that the version of the ipso code that is relevant to this case is slightly different to that which was cited in Campbell. And I'm anxious to make sure that your lordships and your ladyship have the right one. It's actually even clearer, in a sense, in terms of what it requires of the defendant newspaper editor. But I simply ask your lordships and your ladyship to turn to the second volume of the authority company, tab 40, page 1036. And at clause 2, below the hole punch on the paper version, in the first column of the code, one finds privacy clause. At Roman 2, I draw attention to editors will be expected to justify.
You're just going to have to wait a second, I'm afraid.
I'm so sorry.
Where are you in the code of practice?
It's clause 2, left hand of the 3 columns, which should be on 1036.
Privacy.
Correct. Headed privacy. Roman 2. Editors will be expected to justify intrusions into any individual's private life without consent. In considering an individual's reasonable expectation of privacy, account will be taken of the claimant's own public disclosures of information and the extent to which the material complained about is already in the public domain or will become so. Just pausing there, if I may briefly deal with one of my learned friend's complaints about the judgment, which is that the learned judge did not have in his mind those provisions in the code to do with disclosures of information already in the public domain or will become so. It's quite clear that he did, and in fact we cited these very provisions in our skeleton argument. And I think it's paragraph 32 of his judgment where he refers to the code. And the idea that just because he doesn't specifically refer to any bit about disclosures of information, we say is for the birds.
What was the change from Campbell?
Well, it's a fairly minor change, but the I think it's the way in which the editor is required to justify the intrusion is very slightly different. I'm just struggling to find my copy of Campbell. Can you just give me the paragraph? It's 393. A publication will be expected to justify intrusions. And then, so there's a small difference there. When one gets to the public interest, non-exhaustive public interest examples, there may be exceptions to the clauses marked asterisks where they can be demonstrated to be in the public interest. 3, protecting the public from being misled by an action or statement of individual organisation. That, I have to say, doesn't seem to be materially different. I think it's probably just the difference between the publication and the editor, or editors, I should say, in the governing wording of clause 3 under 2. But the first point is, as I say, there's no there can't be any serious doubt that the judge had those provisions in mind, and indeed the reason we relied upon them was precisely because it could not be fairly said that the claimant had put the private information of which the contents of her letter consisted into the public domain, nor was she about to at the time of the defendant's publications. So, applying the code told against the defendant, not for it. Now, I do have a slightly different point in relation to the book, which I'll come on to. So, my Lord, that's just a brief word about the ipso code. Before the adjournment yesterday, we were dealing with the judge's analysis of what the article said about, what the People article said about the letter, and what the defendant could arguably, justifiably say, published from the letter in the light of that. And another document which was before his lordship, which might be of assistance to you, was a schedule to our skeleton argument, which we relied upon as helping to demonstrate the limitations to the case of inaccuracy in the People article. It's in it's at page 190 of the supplementary bundle. I hope the court will find a colour version, a coloured version of what is described as Schedule A. Comparison of People article with letters. And the starting point...
which page is it?
SB, Supplementary Bundle 190.
Oh, 190.
I'm so sorry. What?
I had 90, sorry.
Black and white, still.
I'm so sorry. That's... Perhaps I could hand up 3 colour versions, because...
Is it any different to the colour on the screen?
You should have yellow first colour, green highlighting I love you, and then blue, please stop victimising me, and then purple.
Yeah, what's the code?
I'm grateful. So,
what's the code?
what
do the colours mean?
We're distinguishing between different items of information in the letter and their analogous references in People. And the point of the exercise was to show, hopefully as clearly as possible, just how minor the inaccuracies in substance were in the People interview.
Well, the judge said that.
And he did, and just so your lordships have it, because it I think, demonstrates graphically just, if I may say so, how right he was. Because those 3 components in the top left of the table, I'm so heartbroken, I love you, please stop victimising me through the media, they are all present in the letter in the ways that appear from the extracts that we have highlighted in the middle column under relevant content of the letter. What is missing, as we accept it, materially, is the last words in the extract from the People interview, so we can repair our relationship. We accepted that was not an accurate characterisation of the purpose of the letter. And I made the point yesterday that the last sentence of the letter itself, in paragraph number 15 in the judgment, which is reproduced at the bottom of the first row in the middle column, I ask for nothing other than peace, that wasn't reproduced in the letter, and in fairness to my client, if a point was going to be, if the articles were going to be used to rebut or I should say correct, the inaccuracy that there was about repairing the relationship. One might have expected fairly that the extract from paragraph 15 would have included the concluding words, which were not a million miles away from repair our relationship. I accept it's not an olive branch, but it is germane. And then in relation to the photo op, for completeness, in the second row, there are the references in purple on the left-hand column to the people interview, and analogously the references in the articles quoting from Mr. Markle's letter, of course not our letter, which we say perfectly, substantially match what he himself had said, what people on interview says substantially matches what her father had said, and the judge dealt with that, we say, appropriately in his judgment, making the obvious point, of course, that this is not her information, it's his information, and he was entitled to publish it, as indeed he did in the articles, but it doesn't assist on the question of what the defendants could justifiably publish in relation to the claimant's letter. And before I move on to what I anticipate to be the defendant's argument on this area, which was something of a radical submission that emerged yesterday, could I try to test the general proposition on deployment of the letter in this way? If one had stripped out from the people interview, in that 25-word passing reference to the letter, if one had stripped out the words "so we can repair our relationship," what could plausibly or arguably justifiably the defendants have published from the letter? We say nothing. The submission that we understood, if we've noted it correctly, Malone and Friend to make in relation to what could justifiably be published from the letter, was that it doesn't matter that the letter was not in the public domain. The way he put it was, if the letter makes a serious allegation against Mr. Markle, and he's entitled to reply, and we are entitled to carry the reply, the fact that the text has not hitherto been in the public domain has very little to do with it. With great respect, we submit that just cannot be right as a matter of principle or on the facts of this case. The idea that you're entitled to bring into the public domain the contents of a private letter just because the letter makes a serious allegation against Mr. Markle, assuming for present purposes it does, we say simply cannot pass muster, completely contrary to basic principles of privacy law. It also begs far too many questions. Setting aside just what allegations that the letter did make against Mr. Markle, Malone and Friend says he's entitled, and if he's entitled to reply, well, what he's entitled to reply to is the public attack. That's the ipso justification that the defendant was invoking. It was correcting the record, but more properly.
I thought he accepted that, and I thought he said that the response was to three things the judge did not emphasize from the People article, which was partly the olive branch, and then the allegations about the wedding.
Yes.
And I thought that's what he said.
Yes, I think it's tied in with the wedding allegation, but we say it just doesn't, logically it doesn't work. One has to...
Well, I don't really understand, because I'm not sure that the letter said anything different about the wedding to what the article said. I mean, the article said that the Duchess had behaved entirely properly in relation to the wedding, and so did the letter.
Yes. Well, my lord, it's quite right. What the letter does, the letter contains a detailed account of all the ways in which, in her view, her father's conduct had to use her phrase, broken her heart. Mm-hmm. And those included a number of different topics, including the lying about the staging the paparazzi photographs, that he hadn't returned the 20-plus calls, and that he spoke to her only through the media. And there was a bit of reference to the wedding. But as your lordship says, there was nothing about the very narrow reference, which I think is now being elevated to some importance, about him not getting into the car when the taxi was provided for him to go to the airport. If that's really what it boils down to, I'm afraid to say I simply don't understand the submission, and it doesn't work as a matter of principle or as a matter of logic. On reply to attack, I'm very anxious not to waste too much time on this topic, because my learned friend did concede that it's just a question of public interest, right to correct the record. That's the relevant heading. He did refer to Adam and Ward, but even if somehow the common law principles of qualified privilege, reply to attack, were to be thought to be relevant, they wouldn't help either, for the simple reason that, first of all, the attack has to be the attack cannot be a false or unjustified one. Indeed, in Adam and Ward, that was precisely the factual basis upon which the court upheld the privilege, that the plaintiff admitted that his attack on, it was actually a third party, not the defendant, was false. But it goes further than that, because it's quite clear on established authority that for this sort of privilege to exist, the reply has to be fairly relevant and proportionate to the attack. And my Lord Justice Bean, I think, has dealt on the High Court bench, I think, with a couple of cases where this very issue was visited as a matter of law. But there's absolutely no doubt that all it does, it doesn't help. All it does is bring us back to the same questions of proportionality and relevance. And again, for your lordships and your ladyships, note we've put in the reference from, there is a reference from Duncan and Neal, may have been my learned friends who wanted it in, towards the very end of the second authorities bundle, at 1086, tab 43, 1086. Under reply to attacks, paragraph 17.25, I think I can just pick it up at the third sentence. Provided that such statements are fairly relevant to the rebuttal of the attack, and the ambit of their dissemination doesn't significantly exceed that of the original attack, their publication will be the subject of qualified privilege. And then there's a reference to Adam and Ward. And what is said in Adam and Ward in the citation, which I think my learned friend did refer to, but by reference to the authority, about, this is the third line from the bottom of the citation, if, having regard to all the circumstances of the case, he might have honestly and on reasonable grounds believed that what he wrote or said was true and necessary for the purpose of his vindication, although in fact it was not so. That's all predicated on the assumption that the reply is fairly relevant and proportionate. And one sees a more modern reference in footnote 5 to Mr. Justice Eadie's decision in Hamilton and Clifford. If I can just pick it up at the end of the first line, he summarised the scope of the defence by saying that a defendant is entitled to protect his reputation by a proportionate response which is appropriate both in terms of subject matter and scale of publication. So the short point is that no trial court would be assisted by evidence from Mr. Markle of whether he honestly or reasonably believed that he was entitled to reply to the attack. Far less that he was entitled to reply in the terms that he did, with all the extensive extracts from the letter. It's for the judge to decide, objectively, whether the interference, the assumed interference with the privacy rights of the claimant were justifiable. And that, of course, crucially depends upon proportionality and relevance, and indeed whether or not the attack was true. But that only is relevant if one gets past the other hurdles. Conceptually, the question of what a defendant might reasonably deploy of somebody else's private information as part of a public interest offence is obviously different conceptually from the question of in what language may a defendant defend himself against a defamatory attack. But these principles are dealing with very different policy considerations, and we submit the court just is not assisted by reference to reply to attack. On the question of whether the test is objective, I had thought that it was common ground that both at stage 1 and stage 2 the test is an objective one. It's the judge directs himself in those terms in the judgment. If it is to be disputed, there is authority in the form of this court's decision in Ali versus Channel 5, which, if necessary, we can make available to the court.
I thought he said it was objective in paragraph 31.
He did. And
Mr. Caldecott accepts that.
If that's accepted.
What do you say, Mr. Rushbrook, about the contention that the judge confused public law and private law effectively, transposed the, I can't remember the number, I'm afraid,
the House of Lords, the Supreme Court decision,
yeah.
JR 38.
Exactly.
Yes.
Confused that with Campbell, and didn't really understand how one read across Article 8 and Article 10, where the parties were private and not public authority.
Yes. The nub of the complaint, if it amounts to anything, must be that JR 38 was a public law case where no other rights were in play, specifically Article 10 rights. Whereas in this case, there were Mr. Markle's and the defendant's Article 10 rights. And therefore, as I think it was put, the balance was skewed, both at the stage 1 and the stage 2 test, because the judge misdirected himself by having regard to the very important difference between the rights in play. That cannot be right. If one looks at the...
Well, it's where the judge seems to have put a burden of proof on the defendants in relation to freedom of speech. And I can't give you the paragraph number because I haven't got it in my mind, but the judge, there's a sentence in at the end of a paragraph where he makes it sound as if the defendant newspaper has a burden of proof, whereas of course Article 10.2 is about displacing, it's the reverse of that.
Yes, well, Lord, it's paragraph, I think, 30 of the judgment that your Lordship has in mind. I mean, the short answer to where I'm going with this is that when one looks at the judgment as a whole and all the places he refers to the exercise he's carrying out at the stage 2 test, it's perfectly clear that he is applying the relevant balancing exercise as a parallel analysis. He's not presuming anything in favour of the claimant or imposing an unjustified burden on the defendant. I'm sorry, it's paragraph 35.
35, yes.
35. What that reference at the end of the paragraph is to our submission before the judge below, which the judge, to be fair to him, is setting out. That, to be strictly, I think we probably need to divide it into two. There's the question of whether there's a burden of proof that the defendant is charged with. And then there's the question of whether the judge ignored the fact that there were Article 10 rights in play. On the first question, I think I did address this yesterday, but just so the court has our submissions clearly, this wasn't a case that turned upon the burden of proof, because if one looks at the painstaking analysis that the judge undertook...
Attention please, attention please. This is the Security Control Office. You are now invited to observe a 2-minute silence to mark the anniversary of Armistice Day. Thank you. Attention please, attention please. This is the Security Control Office. You are now invited to observe a 2-minute silence to mark the anniversary of Armistice Day. Thank you.
If one reads on, so first point is that he was reciting our submission, and our submission was itself a citation from ZXC and Bloomberg, paragraph 46. We don't need, I submit, to get into a debate about whether or not paragraph 46 of ZXC is binding on this court, or that was it per incuriam because of its reference to JR 38. Because if one looks at the substance of this judgment, and indeed when he goes on at 36, he places no emphasis on the burden of proof, but he talks about the well-established two-stage approach in domestic law, and that the two-stage analysis is, however, a fair and convenient one to adopt. This is the framework that has been adopted by the defendant in its approach to the issues. And of course, one has to bear in mind also that this is all subject to the preceding paragraphs 30 and 31, and indeed 32, where he sets out exactly what that stage 1 and stage 2 process is. We submit impeccable form. Self-evidently, there could be no suggestion that that summary of the principles at stage 2 was leaving out of account free speech rights of the defendant or Mr. Markle. They're absolutely fairly and squarely in play in paragraph 31. Again, I think, to dwell on it too much, but at 32, of course, he does refer to the code of practice. And it is, as it happens, worded in the way that the court has seen, which does call upon the editor to justify its interference with privacy right without consent. Now, I accept that's not a formal burden of proof, but it is nevertheless part of the architecture of our law, because Section 12(4) of the Human Rights Act requires the court to have regard to the code. If one then moves on to the other bookend of the judge's analysis on stage 2, which is his conclusory paragraph at 128. It's quite clear, we say, again, this is cannot be faulted in terms of his legal approach. It's quite clear that he's asking himself the right questions about the balancing exercise. He does so by reference to, as one sees, an objective review of the articles. And he concludes that the articles, save to the very limited extent I have identified, this is the middle of the paragraph, the disclosures made were not a necessary or proportionate means of serving that purpose. For the most part, they didn't serve that purpose at all. Taken as a whole, the disclosures were manifestly excessive and hence unlawful. No prospect that a different judgment would be reached after the trial. The interference with freedom of expression which those conclusions represent is a necessary and proportionate means pursuing the legitimate aim of protecting the claimant's privacy. And forgive me if I'm repeating myself, but that reference to necessary and proportionate is an unexceptional way of putting the matter in the same way that Baroness Hale and Lord Carswell do in Campbell, where they use those, themselves refer to necessary in a way which, as I say, is context is everything. This is essentially an alternate or a proxy for justified. And, my lords, if that isn't good enough on the judge's approach, there was criticism of 1064 on page 151, 106 of the judgment, subparagraph 4, whether the publication was necessary and proportionate in pursuit of the available justification, and then the reference to sick leave. If one takes, it's all very well focusing on subparagraph 4 and saying, aha, that's an inappropriate reference to necessary, and it's importing the wrong JR38 analysis. But again, one has to look at it in context. And the context starts at 104 and I think perhaps the most convenient way of dealing with it, would the court be good enough to read from 104 down to the end of 108? Because it's very important to see all of the context in which subparagraph 4 of 106 appears. Looking at that as a whole, it's abundantly clear that everything that possibly could be said on behalf of the defendant that needed to go into the balance was put in the balance by the learned Lord Justice. And it's absolutely clear from 108 that he's making the very distinction between a private law and a public law case that my learned friend suggests he was failing to have regard to. The purpose of his citation, his reference to Campbell, is precisely, one might think, amongst other things, it shows he had very much in mind not just the defendant's Article 10 rights, but Mr. Markle's. So on any view, simply cannot be fairly said that this judge, who has vast experience and long experience in this area of the law, who expressly says that he has Campbell in mind, beginning of 106, proposition that he was applying the JR 38 test or analysis, disregarding the defendant's Article 10 rights, let alone Mr. Markle's, is utterly hopeless. Before I leave that topic, at 104, could I just observe that the way he expresses himself is, we would say, absolutely alive to the need to put the burden, the bar at the right place from the defendant's point of view. He's not imposing too high a bar on the defendant, because he says the real issue on this part of the case is whether the publication complained of might be justified. Not even was, might be justifiable. And then at the last sentence, if there's a real possibility that the publication complained of might be found justified on this basis after trial, I ought not to strike out or grant summary judgment. So as a matter of express language, both at 104, 106 and 108 in context and as a matter of substance, simply cannot be said that he misdirected himself in law and applied the wrong approach. On the use of necessary, even in the private law context, just so your lordships and your ladyship have the reference, Baroness Hale in Campbell says,
Which paragraph?
I'm so sorry, 152, that consideration, that's in other words the fact that she had publicly denied being involved with drugs, justified the publication of the fact that, contrary to her previous statements, Miss Campbell had been involved with illegal drugs. It also justified publication of the fact that she was trying to do something about it by seeking treatment. It was not necessary for those purposes to publish any further information, especially if this might jeopardise the continued success of that treatment. And again, Lord Carswell at 170, a similar effect, just picking up the last two sentences. I consider that that's the deployment of the photographs and additional material constituted such an intrusion into the appellant's private affairs that the factors relied upon by respondents do not suffice to justify publication. I'm unable to accept that such publication was necessary to maintain the newspaper's credibility. The short point is that the use of the word necessary in Lord Justice Warby's judgment in 128 is no different to the use of the word necessary that one finds in those two speeches in Campbell. And I think a point was taken about the other paragraph that the learned friend fixed upon was 1255 of the judgment. It was neither necessary nor proportionate to disclose any of the rest of the information in the letter for this purpose. We say that's simply the judge doing exactly the same thing as Lord Carswell and Baroness Hale did in the private law case of Campbell. So any attempt to trip the judge up on the use of language, we say, must fail. On other errors of law, it's also said that the judge skewed the balance in favour of the claimant at stage 1. And I think the way it's put is that he failed to assess the strength of the claimant's privacy rights. And that by failing to do that, in comparison with the rigorous weighing of the defendant's Article 10 rights, and indeed those of Mr. Markle, that he was in effect skewing the balance and requiring, setting the bar too high for the defendant. Our response to that is, well, first of all, nothing new in this submission. One can't pick through the bones of particularly a very, very long judgment like this and say that just because something isn't mentioned, it follows the judge didn't have it in mind. Again, as a matter of common sense, the idea that he was completely oblivious to or had no regard for the nature or strength of the claimant's Article 8 rights is very difficult to construe from the judgment as a whole.
But does it matter? Because in this case, it seems to be tacitly, not expressly, because Mr. Caldecott did say that she did not pass stage 1, but I think he didn't put that at the forefront of his submissions. So let's assume, for this purpose, that she did pass stage 1
yes.
narrowly. Let's assume that,
yes.
because she had put some material into the public domain. The Article 8 right was weakened by the circumstances, the various things that he relies upon. For summary judgment, you have to show an answer which Mr. Caldecott accepts is a binary question.
Yes.
Did you have a reasonable expectation of privacy or not?
Yes.
If you pass that hurdle, you must go on to the balance. If you then consider the balance and there is no reasonable triable issue which could show the balance to be tipped in the defendant's favour, then you are presumably entitled to summary judgment. Is that right?
My lord, that is right, and that's pretty much the way that this court put it in the Prince of Wales case. I think I should just take you to that, because my lord has already, if I may respectfully say so, rightly observed that this is an evaluative exercise that is on appeal. And the court will be more than familiar with the test that faces an appellant who's trying to overturn a decision of that kind, whether one calls it evaluative or exercise of discretion.
I'm not, I mean, with respect, I'm not entirely sure about that. If Mr. Caldecott shows that there is a triable issue that should have been, could not be determined on a summary judgment and needed evidence which would have been capable, had it been decided all his way at trial,
Yes.
would have been capable of shifting the balance his way at stage 2. He wins this appeal, whatever evaluation the judge made. Your submission, as I understand it, is he can't win that because the only justification for breaching privacy here by the defendant was either in the public interest or to set the record straight. And in both cases, the People article did not demand the publication of the letter for that purpose on any analysis. That's what you said. And as I understand the case, if you're right about that, well, you're right about that. The appeal fails. So, I mean, I'm very keen to look at the Prince of Wales case. I'm not trying to take you out of your course, but you said, I had said it was an evaluative exercise. The judge was actually looking to see whether the defendant could win.
Yes.
And he concluded he couldn't for the critical reasons in paragraphs 124 to 128.
Yes, my lord, respectfully agree, and I don't think I could add to your summary of what the judge was doing, save possibly to say that he, not only did he carry out the exercise that he did, but he did it expressly against the background of assuming in favour of the defendant all of the factual allegations that he felt, in his view, were arguably relevant. And I think I only need to refer to paragraph 23 of Prince of Wales, just so that the court can see the way in which it was dealt with there, which is precisely the same issue that's before the court in this appeal. It's page 611 of the second bundle. It's short and to the point.
Sorry, let me just find it.
It's tab 26, second bundle, page 611.
Paragraph 23.
23. For these reasons, we reject Mr. Warby's submission that there are issues of fact unresolved that call for a trial. The issue on this appeal is whether the judge's application of the law to the facts that were either undisputed or assumed to be those advanced by the newspaper produced the correct result. That is precisely the same question that arises here. I think all I really want, by reference to evaluative exercise, I wanted really to accept in my learned friend's favour that we're not just talking about an evaluative exercise at trial. We're talking about the one conducted against the background that the judge did, namely summary judgment, but crucially where facts are assumed to be true in favour of the defendant. So at that point, the argument must shift to the question of, well, did the judge leave out of account some arguable fact that he didn't assume to be true that might affect the outcome? Because if we are right, and he assumed in favour of the defendant everything which needed to be assumed for the purposes of the exercise he carried out, then the appeal is doomed, because on our submission, the defendant has not pointed to any error of principle or law or approach in the exercise which, as my Lord says, he carried out in detail on the balancing exercise. And for that reason, the submission that the balance was skewed at stage one really goes nowhere. On the question, the now topical question of what did the judge assume to be true in favour of the defendant, I think I said yesterday that there were numerous references in the judgment, and for your lordships and your ladyships' assistance, I ought to just take you to them now. And one sees not just how generous he was to the defendants at that stage, but we'll also see when I come to it later that the position factually has actually weakened from the defendant's point of view. I don't need to make that point, but it is important so your lordship see what's gone from the case, to see that in fact the judge was overly generous to the defendant. But on the stage one, at 66, he expressly says, two main questions. First, whether the defendant sets out any case which, assuming it to be true, provide a reasonable basis for finding that there was at any material time no reasonable expectation of privacy. A bit further on, nothing that the defendant has pleaded in answer to this part of the claimant's case provides any reasonable basis for defending the issue. 72. Last sentence. This is under Factor 1, the claimant's status. It's in my judgment impossible to say that the factors listed in the pleaded case or in submissions, assuming the facts were made out, could have such a significant bearing on the answer as to lead the court to conclude that alone or in combination with the other circumstances they deprive the claimant of any reasonable expectation of privacy. 77 to 78, still under stage 1. This is factors 2 and 3. At 77, he summarises the defendant's plea in this respect. This is about father's intentions, or presumed intentions. And then at 78, halfway through, but even assuming the facts to be as pleaded, they are not capable of defeating the claimant's case that, objectively speaking, she had a right to expect her father to keep the contents of those rights may be ignored or violated. Factor 4, public domain, at 84. He accepts in favour of the defendant. In fact, we say wrongly. He accepts that the authors were given a copy of the letter, even though it's not pleaded, before reaching, we say, the correct conclusion is, doesn't matter how the quotations got into the book, all that matters is the timing and extent of publication, which is plainly not enough to defeat the claimant's rights against the defendant, even from the date of the publication of the book. 86, under the heading of other disclosures or alleged disclosures by the claimant. It's a zone of privacy argument. This is effectively, I think, gone from a learned friend's submissions anyway, but again, last sentence, it is in my judgment fanciful to suppose that a court might find after a trial that any of the other disclosures or alleged disclosures alone or in combination, place so much relevant information about these matters in the public domain that the claimant lost any right to privacy in the contents of the letter. So again, assuming in favour of the defendant that it might make those out. 88, this is under the claimant's intentions as opposed to what she's supposed to have expected her father to do with the letter. Now I do stress that much of this case is now gone, but 87 sets out what the line of argument is. The pleaded case, this is the second sentence, is that the court should infer that the letter was written and sent with a view to it being read by third parties and or disclosed to the public, alternatively knowing that the same was very likely. Moving down to the bottom, towards the bottom of this paragraph, an inferential case is advanced that the claimant was considering using the letter as part of a media strategy to improve or enhance their image. And then at 88, he goes on to say, it's fair to say this inferential case is not very precise or clear. It doesn't appear very compelling. If your lordships and your ladyship would just read on to the end of that paragraph, and in particular the second last and last sentences of that paragraph.
In 5 lines from the bottom of the paragraph, what did the judge mean by such information? Claimant is happy to have such information put out publicly.
That is a, I think that's a reference to the very long list of items of information that appeared in the book under 52D. There was quite a lot of factual dispute about this because we said they plainly wouldn't, that they were plainly not information that could have come from the claimant, not least because so much of the personal information in the book was inaccurate. But setting that aside, this is part of a zone of privacy argument that Malone & Friend has now abandoned. So, short answer, what is it? It doesn't matter anymore, but that is what he's referring to. He's referring to the argument that you're happy to provide the authors of the book with a whole load of items of information regarding your family or your friends. And that disqualifies you or reduces your expectation of privacy in relation to the letter.
Has that been abandoned?
I think it, well, I understood Learned Friend to say he no longer relies on anything other than disclosures in relation to the letter. But the point in 88 is that he is assuming in favour of the defendant that those disclosures to the author were made by her on her behalf. And he rightly holds that they are irrelevant because they're not in the right zone. It's fair to say that 88 is dealing with more than one aspect of the defendant's case on this. That's why it comes in under the defendant counters. Then at under stage 2, again the introductory assumption is at 97 in relation to factors already relied on. Naturally, the defendant relies on the facts that I've already discussed as matters to be taken into account at the second stage. Said to make the privacy interest slight or compromised any expectation. In my judgment, taking the defendant's case on each of those factors at its highest, there would be no real prospect of the court striking the balance against the claimant in favour of the defendant and its readers. I should say, my Lord, in response to my Lord Justice Bean's earlier question, that the reference to the various items of information that appeared in the book, this is all in relation to stage 1, expectation of privacy, where it was, as we submitted and the judge accepted, utterly hopeless. But he's also assuming in their favour, for the purposes of stage 2, that those factors could be made good factually. At 99, this is important. If I could pick it up at the second sentence, in relation to her status as a public figure. That interest would... it's not possible to imagine a court concluding that this consideration outweighs a claimant's privacy interest in the contents of the letter. That interest would, for the reasons given above, be bound to weigh heavily in the balance. Prior publication about its existence and nature, he goes so far as to say that, could weaken that interest somewhat. So might an intention to make public the same information at some stage. But the most that is alleged in these respects is that the People article was authorised by the claimant and that she passed information about the contents of the letter to friends and to the authors. As I've noted, the defendant does not plead that the claimant provided the authors with a copy of the letter. The prospect of the defendant obtaining evidence to support the hearsay evidence of Mr. Verity and contradict Mr. Scobie's witness statement on the issue seemed to me remote for all manner of reasons. I would class the notion as fanciful. But even if that were wrong, I cannot envisage a court attaching any great significance to this factor at the second stage. And that's an important passage because it deals with the complaint that the judge only made the assumption about provision of the letter or information about the letter in respect of the public domain issue. But he doesn't. He makes it fairly and squarely in respect of stage 2. And he doesn't just accept the defendant's case at its highest. He actually goes above and beyond it and accepts the possibility, which he regards as fanciful, that the authors were provided with a copy of the letter. Then at 100, he deals with 2 further factors. Fact and content of the disclosures made to the authors for the purposes of the book and what these are said to show about the claimant's attitudes towards publicity for and about her private life and the private lives of others. Well, that more actually is picking up again on what was the subject of your Lordship's question at 88. The defendant invites the inference that the claimant is ready and willing to publicise details of her own private life and those of others, including correspondence, and that she doesn't object to publicity about her so long as it is favourable. These are matters which are hotly contested. I cannot possibly resolve the factual disputes which arise, but nor do I consider that these matters could supply the element that is otherwise missing from the relevant factual matrix. And he goes on at 101 to recite the law on zone of privacy. And importantly, in the second last sentence, a person who actively seeks the limelight may have a correspondingly reduced expectation of privacy, but the analysis must be focused, not broad brush. What is alleged here cannot be regarded, in my judgment, as a factual case capable of showing that the disclosures complained of contributed to a debate of general interest. And just so your Lordships and your Ladyship have a flavour of the sort of stuff we were talking about, we did spend some time on this below, because we said factually the case was hopeless. There were various items of information which, I think there were 49 of them, which were pleaded out under 52D of the re-amended defence, which were demonstrably, as it happened, nearly all in the public domain. Some of them had actually come from the defendant's own articles on aspects of the claimant's life. But they simply were not capable, on our case, of doing the job of amounting to any significant disclosures of relevant personal information about her life, or indeed others' lives, such as to weaken her rights in relation to the letter. And that's what the judge is dealing with in this passage, even, we say rather generously, assuming in favour of the defendant that those references in the book could be laid at the door of the claimant. 102, again, he assumes implicitly in the last sentence of the paragraph that the claimant did provide the letter or information about it to the authors with a view to publication, or wrote it with a view to later publicity. But again, we say correctly, concluded that she would have been well within her rights so far as her own privacy is concerned. 107, in relation to the public interest justification for disclosure of the private information, specifically under the heading of correcting the record. 107, the judge accepts for these purposes that Mr. Verity's evidence would be accepted in full if there were a trial. And this is effectively the evidence of, I thought it was reasonable and in the public interest to publish all these extracts from the letter. He does endorse Mr. Markle's view that the People article misrepresented the letter, but he goes no further in the sense of factually standing behind any of Mr. Markle's allegations or rebuttals. It's effectively the sort of statement that one often gets from a newspaper editor saying, I thought this story was in the public interest, and that our readers would be interested in seeing all these extracts from the letter which were necessary to give a proper flavour and authenticity to the story. Judge accepts all that, factually, but goes on rightly to alight on what really matters, which is whether, objectively speaking, giving due deference to editorial beliefs or considerations, the intrusion nevertheless went too far and was disproportionate. 113, this deals with the very, very narrow spat about whether or not Mr. Markle had refused to get in the car that had arrived to take him to the airport. This is contested, but assuming this to be true, it could not provide a rational or arguably proportionate reason for disclosure of any part of the letter. Whether my learned friend agrees with that conclusion or not, and it's for this court to say whether or not there's anything in the objection, it cannot possibly say the judge failed to have regard to it. I think that is it in terms of references to the factual basis being assumed in favour of the...
Did he deal with the question of the wedding, the events of the wedding, and the letter being published as a rebuttal of what was said in the People article about that?
Well, my lord, it depends what one means by events of the wedding, because yes, insofar as they were put to him, is my short answer. We can't find anything in his analysis, anything missing from his analysis that was submitted to be of arguably important relevance on the balancing exercise. Sorry? On the question of the text, he does, and he was taken in some detail by me to the text. He expressly refers to the text messages that passed to and from in the lead up to the wedding. They are included in subparagraphs 1 to 8 of paragraph 40. And could I just say on the question of the text messages, one thing that we didn't understand to be in dispute was that the conversation that took place a week before the wedding, when the claimant has learned of the forthcoming Mail on Sunday article, no dispute that conversation took place between the claimant, her husband, and the father. And we didn't understand it to be disputed, that Mr. Markle was not truthful to them when he denied that there was any truth in the paparazzi story. The real point is that that doesn't matter, because when one looks at what the letter says about it, she gives chapter and verse on what did happen. And I took you to the reference yesterday in the letter towards the end, which ended up with the CCTV footage coming out. Well, I can't remember whether she actually used the word lied, but there's no doubting that the factual account that she was putting forward in the letter, and therefore for the reasons that we were considering yesterday, it couldn't possibly serve to justify any public interest defence to deploy parts of the letter that, as it were, told her version of the truth. Yes, Ms. Phillips reminds me that his preface to paragraph 40, he notes that there is a level of dispute as to the precise sequence of events, and that the defence presents a somewhat different take on what took place. It is, in my judgment, unnecessary to make detailed findings about this or about the rights and wrongs of what went on at this time. It is enough to say the following, which is in the papers before me and either common ground or clear. And subparagraph 1 refers to that conversation. And it's perhaps important to point out that he doesn't assume against the defendant that Mr. Markle had lied when denying in this conversation that took place that he had colluded with the paparazzi. He simply refers to the fact that her father had apologised. That apology is absolutely clear in the text messages, his willingness to apologise. And in respect of the numerous calls, again, he refers to the text from the claimant's husband. This is subparagraph 8. Stop talking to the press for your sake and hers. Prince Harry expressed concern that, as he said, Mr. Markle hadn't returned any of our 20-plus calls since we all spoke on Saturday morning. A grieved message was sent from Mr. Markle's phone in response, which said he knew nothing about receiving 20 phone calls, suggested that he'd been ignored. I don't need to quote the following text. The messages did not address the request to stop speaking to the press. Under 41, all of the correspondence to which I have referred, including the telephone call, was personal and private in character. There's no basis on which to suppose that any of it was created, crafted, or curated by the claimant or Prince Harry for the purposes of public consumption. The defendant makes no such suggestion. So, in fairness to the judge, and indeed to all parties, he recites the material events in his view without finding it necessary to reach a conclusion on the facts. It can hardly be said to be unfair to the defendant, absent some cogent and logical reason for thinking that any of what transpired in the week leading up to the wedding provided a justification for deploying the extracts of the letter. So again, we always come back to this question of what the contents of the letter were. And they were all, putting it bluntly, they were all one-sided. Hardly surprising, since the letter came from the claimant. As it happens, I think there were 7 or 8 references in the texts to the claimant or her husband saying, please pick up the phone, we're trying to call you, please pick up the phone. Then there's the reference to the 20 plus phone calls towards the end of that week. We actually didn't understand it to be disputed that they were a correct reflection of what had happened, but if it isn't going to be accepted, we say it doesn't matter because it cannot bear upon the justification for the disclosures of the letter. Could I move on to the complaint about AAA? Which I think I can deal with relatively shortly. The way it's put is that the judge failed to have regard to the conduct of the claimant or sufficient regard to the conduct of the claimant prior to the publication of the articles. And indeed, I think it's said beyond the publication of the articles. And relies upon the AAA case as saying that if a claimant is ambivalent about the protection of her private information, displays sufficient ambivalence about it, then that may be a factor which I don't think it's now said extinguishes, or maybe it is. In AAA it didn't extinguish, it merely diminished the reasonable expectation of privacy which the judge in that case found to exist in respect to the information. The AAA case is a perfect example of a case which is not helpful to the facts of this case. An important distinction is, or I should say, the inquiry must focus on what is it that the claimant is alleged to be ambivalent about. In AAA, we were talking of, the court was dealing with a single item of information, namely relating to the paternity of the claimant's child, which was either out in the public domain or not. It qualitatively didn't have the same dimensions or nuances, self-evidently, of the contents of a private letter. So one needs to approach AAA with care. And the real question is whether or not anything that the defendant pointed to by way of alleged conduct on the part of the claimant demonstrated, or arguably demonstrated, sufficient ambivalence, to use that word, with regard to the contents of her letter. That's the question. And the answer to that, we say, as the judge rightly found, was no. The devil, again, is in the detail, and the defendant's case at its highest went no higher than the 25-word summary of the letter, which appeared in People magazine, which the defendant describes as a description of the contents of the letter. We wouldn't accept that as a fair characterization of what it was. It was a brief passing reference to a very, very long letter. The key question is, did she arguably display sufficient ambivalence to the contents of the letter? And even assuming that she had authorized friend C, I should say the long-time friend, who's quoted in People, even assuming she had authorized the long-time friend to provide that information in relation to the letter, it couldn't possibly justify the deployment of the extensive extracts. There's simply an unbridgeable gap between that 25-word reference and the contents of the letter. It does raise this question of control when one looks at what's alleged to have happened after the publication of the articles, because of course the defendant relies on the book. We say, and the judge also said, in effect, that she could have provided the letter to the authors for publication. Perhaps all of it. And that wouldn't undermine or prevent the claimant from asserting her rights in respect of the letter. He's right about that. Because any other answer leads to the proposition that the editor of a newspaper has the right to decide when to first publish a private letter, not the writer of the letter. We say that is not the law of this country. It would also invite questions about, well, at what point does the writer of the letter lose their right of privacy? On the facts of this case, the disclosure, not of the letter, but information about it, is alleged to have happened before the defendant published its articles, but the book doesn't come out until a year and a half later. Now, assuming that which again is not even pleaded, that knowing that the book was in preparation, she had given a copy to the authors with permission to publish it. Is it said that the minute she makes that decision, that gives the editor of the newspaper the right to step in and say, aha, you're intending to publish this letter, so we can get in and do it first? Obviously cannot be right. Again, one goes back to Campbell and Roddy. It's for the claimant to decide when, to whom, how much of, and how to share her private information. And that is why, on analysis, the only relevance that the book disclosure, if I can put it that way, cannot add anything to the people disclosure, because the only relevance of the people disclosure is, as pleaded, that it constituted an attack upon Mr. Markle that he was entitled to correct. Self-evidently, anything that came out in the book came out a year and a half after the defendant's own articles. So it couldn't possibly serve as any sort of public interest justification for the disclosure, the publication of the extensive extracts from the letter, occurring so long after the event as it did. So not only does it not add anything to the people disclosure, bearing in mind that they are said to be the same information is alleged to have been provided to the authors, but it's actually a lesser case. It doesn't work because such attack as the book contained on Mr. Markle was published a year and a half after the articles. Now, as it happens, we say that factually the case on the book was hopeless anyway, because all Mr. Scovey did, and he puts this in his witness statement, is lift the a very small part of the extracts from the letter that the defendant itself had published. That was an issue which the judge rightly expressed scepticism about the defendant's case on, but he was prepared to assume in favour of the defendant that the authors of the book were provided with the same information as appeared in People. Could I just briefly deal with it's described by my own friend as fresh evidence. Actually, what's before the court is two witness statements, but also the text messages provided after the witness statement of Mr. Now, and a complete set, I say complete set, subject to this qualification, the emails that Mr. Nauf discovered dealing with his contacts with the authors were in fact less than those that the claimant was able to locate when doing her own email searches after provision of Mr. Nauf's witness statement, albeit there wasn't much in terms of emails. Before I do so, just in context, a document which the court wasn't taken to, but which is the important background event to the writing of the letter, is the article of 28th of July, which was published in the Mail Online, supplementary bundle, page 308. This is the an article which is referred to by the judge in his summary of events. Paragraph 42.2, which I don't ask you to go to, but it's a long article, headline, perhaps it'd be easier if I was dead. Heartbroken Thomas Markle says his daughter is ignoring him and has changed all her numbers since marrying Harry, but he won't let the appellant silence him. At the bottom of the page, Thomas Markle today claims in the Mail on Sunday that Meghan has cruelly excised him from her life and he fears he may never see any children she and Harry may have. Over the page at 309, I'm not going to read all this, but just a few bits that are relevant. Retired award-winning Hollywood lighting director Mr. Markle hasn't spoken to his beloved Bean, his childhood nickname for Meghan, for more than 10 weeks, and claims the rift is punishment for him staging fake paparazzi pictures for the wedding and then daring to speak out in his own defence. I'm really hurt that she's cut me off completely. I used to have a phone number. They cut me off. Those numbers were disconnected. They no longer work. I have no way of contacting my daughter, he says. Just for the avoidance of doubt, that is disputed as a matter of fact between the parties, but it doesn't matter for present purposes. 311 staging fake paparazzi pictures, this is the second last paragraph, including one of being measured for a wedding suit at a shop in Rosarito that actually sold party supplies, was a huge mistake, he admits. In an interview with MOS columnist Piers Morgan, he apologised for the fake pictures but broke protocol by revealing Prince Harry's political views. If you then move on to the third paragraph, how tragic is that to deprive a child of its grandfather because I said a few things critical of the royal family. And then there's some rather unpleasant remarks attributed to him, which I think I only need to ask you to read down to the middle of that page, as if there's a special way to apologise to the royal family. Then over the page at 313, he's angry that Meghan has talked about support her yoga-loving mother Doria has given her, but gives him no credit. There's a few paragraphs on that topic. And then in a large sub-headline in 314, there's a reference to Princess Diana, which I won't read. Thomas Markle hits out at Palace for taking strained Meghan away from him and admits he doesn't care if Prince Harry ever speaks to him again. That interview, which was said to be based on a 9-hour interview between Mr. Markle and the Mail Online, which he has disputed, I think, some of the things that are attributed to him, if anything could be described as an attack, a public attack, both on the claimant and on the family into which she had married, it would be this letter. And this was, in causal terms, this was a very important part, a triggering event, that led to the writing of the letter. The difference between her father and the claimant in this respect was that the attack is made publicly. It's self-evidently of a kind likely to cause difficulty in her relationship with her family. She touches upon this in the witness statement. The claimant's response is to write privately to her father. So the language of reply to attack that my learned friend used yesterday struck us as slightly ironic, given the important background to the writing of the letter. And there's always a danger with replies to attack that one actually has to look at where the attack, who made the first attack. But with that in mind, I then need to take you briefly to the claimant's pleaded answer in response to the defendant's case that it was allowed to put on the record in September of last year, to the case that the defendant was then making. It has now abandoned nearly all of it, but the case that the defendant was then making about the genesis and creation of the letter. And in essential summary, the pleaded case against her was that she had written it with a view to publication, or for the public record, as it was put in the grounds of appeal, that she had considered it as part of a media strategy to improve or enhance her image, that she intended it to reach the public domain or thought it was likely, and that she knew or suspected that if Mr. Markle leaked it, that if it was put into the public domain, Mr. Markle was bound to disclose it. And nearly all of that has now gone from the defence, but what matters for present purposes is the case that she pleaded back in November of last year. This is at tab 26, a bundle, core bundle, paragraph 12.7a,
Page.
609 to 611. If I could just ask the court to read from the beginning of 12.7a down to the end of subparagraph 5 at the bottom of 610.
So you have to give me those paragraphs again.
Yes, my lord, starting on 609 towards the bottom of the page, the main paragraph 12.7a, and down through 1 to 5, subparagraphs 1 to 5 under 12.7a.
Yeah.
You'll have noted the reference in 1 to the escalation of the claimant's father's tabloid media interviews and the narrative which then follows about the receiving of advice and her decision to write a letter to her father and her the assistance she got from her trusted advisor, Mr. Nauf, who was the head of Kensington Palace Communications. And at 5, the fairly detailed account of the process of writing it, which was a painful process, she says, a deeply painful process, that Mr. Nauf lived through with her. And you'll have seen the reference to him providing feedback. At subparagraph 6, there is the conclusory paragraph, the summary of the rebuttal of the defendant's case. As is clear from the above, the genesis of and reasons for and intended use of the letter was the complete opposite of the media strategy. It was a private letter written and sent by the claimant to her father on the advice of senior members of the royal family in an attempt to protect her family, including her new family members, from further media intrusion and embarrassment to the institution. The defendant's contentions to the contrary, which are wholly speculative and unsubstantiated by any evidence, are deeply offensive. I don't think I need to read on. Now, my lord, with that pleaded case in mind, will the court please bear in mind that this case was pleaded in November of last year without my client having the benefit of sight of the contemporaneous text messages between Mr. Nauf and the claimant, which have come to light subsequent to Mr. Nauf's witness statement. What is striking about those text messages, when fairly analysed, rather than cherry-picked, as my own friend did yesterday, what is striking is how accurately her account in this part of her amended reply reflects the truth, as it appears from the contemporaneous messages. The only thing which she appears to have got wrong was that the feedback that Mr. Nauf provided, as referred to in subparagraph 5, didn't occur in the course of a discussion, but it was actually provided by text message itself.
I mean, why does any of this matter?
Well, it's first of all, it's important for the court to realise how much has now gone from the defendant's case.
It may be, but as I understand it, your case doesn't depend on the defendant having a lesser case than it had before the judge. You say the judge was right on their greater case before the judge, and presumably by extension, if you're right, he was right about the lesser case.
Yes.
I mean, I can't understand why we're getting into all this stuff, if I can put it this way, about who said one person said the other person said something else. I just don't see that it can affect a right to summary judgment. Either you're right, that there is no reasonably arguable defence on the defendant's pleaded case. The defendant can strike out bits of the pleaded case or put in more things it wants us to ask us to look at. But it doesn't seem to me at the moment that any of the more things they've put in add up to beans beyond what was there before.
Well,
So why do we have to get into an agonising treatment of the text messages that may or may not have taken place, or did take place, unless they add further to the defendant's case, which is not said?
Well, Lord, it's that last bit that was the reason I do it defensively, because it's the defendant's position that somehow their case is strengthened by the new evidence. We say it's actually the opposite.
Well, he assumed in their favour.
Exactly. The judge assumed in their favour that what we say is the higher case would be made out.
Exactly.
The defendant says, oh, well, look at what these texts say. We say, well, actually, they show that she's actually regarding the letter as confidential. She doesn't even allow her private secretary to be shown a draft. So the putting it shortly, my lord, and I say this responsibly to the defendant, there is no real prospect that the evidence that the defendant now relies on could show anything higher than a case that she regarded as a possibility.
Would you say we should admit the evidence?
No, because we say it's all about the characterisation of the evidence. It's only relevant if the defendant is going to suggest that somehow it transforms the case. We say it can't transform the case because all it shows is
can't want the case?
It can't transform their case into something better than was before the judge, because all it shows is that she acknowledged the possibility that her father might leak it. It doesn't support, in fact, it undermines the case that she thought it was likely or wanted the letter disclosed. And as regards the twin point on this, as regards cooperation with the authors, and I can take this very shortly, is that when one actually looks at the only document which matters on dealings with the authors by Mr. Nauf, a great song and dance was made about this by Mr. Caldecott. But what really matters is the information that appears on page 74.18 of the applications bundle. And this is the background reminders to Mr. Nauf of material which, on her case, he knew anyway. This is the background reminders that she includes below just in case ahead of his meeting. What is, again, striking and wholly inconsistent with the defendant's pleaded case below and its new pleaded case, which I trust your lordships are not going to be, and ladyship will not be troubled with, is how little information about her father she was prepared to contemplate Mr. Nauf giving to the authors. And even more than that, absolutely no reference to the letter. Not even the fact of it. She's simply not prepared to go there. This is halfway down the page of 74.19 under the author's topic bullet point, family relationship with family and father, past and present. Every single aspect of those 4 bullet points that were provided were, on any view, anodyne, on her case already in the public domain anyway, and most important of all, say absolutely nothing about the letter. Which is why we say the entire case about her cooperation with the authors simply falls flat. And what your lordships and my lady don't know is that there was a whole series of convoluted allegations in the defence which have now been abandoned, to the effect that she was getting frustrated with her communications team and she therefore decided to bypass them and use her friends as a conduit, that the publication date was put back, so her friends decide to act sooner to put stuff into the public domain, and that's what leads to the people. There's a whole load of factual premises to this convoluted case which have now disappeared. They don't even maintain the allegation that she and her husband cooperated with the authors to put out what they called as, they referred to as their version of the events. That's gone. So what one is left with is a proposition that on its face makes no sense. That whilst on the one hand she is quite openly, as far as Mr. Nauf is concerned, allowing him, as part of the job that he does, this is what he's paid to do, is to deal with media inquiries. She's quite happy to provide him with some background information for his meeting with the authors. But it doesn't include the letter. And she had every opportunity. This was the perfect opportunity if she wanted to put it into the public domain.
Well, I mean, paragraph 7 of the judge's judgment assumes in the defendant's favour that she intended the letter to be publicised, to that end disclosed information about it to the best friends quoted in the People article, for the purposes of their biography, which is much higher.
It is. Well,
I just don't see
I respectfully agree. It's, as I say, it's defensive against this suggestion that somehow their case is improved on the evidence.
Well, we have to try and keep this case within some kind of bounds. I mean, this is an appeal against a summary judgment. I mean, that's a very binary case. They have to show there was a tribal issue the judge failed to recognise on the facts, which he ought to have led to his sending the case to trial or some other reason for a trial. Getting into the facts and determining it by way of mini-trial or otherwise is precisely what we are not able to do.
Well, Lord, I don't need to say any more other than that, first of all, to answer, in fairness to my client, the song and dance that Mr. Caldecott made about it yesterday.
I don't mean to be fair to Mr. Caldecott. I don't really remember a song and dance about all this, but anyway, there we are.
Well, I think that the complaint is that somehow disclosure would transform the case. It's a sort of Macawberite submission.
Well, that is a possible argument that disclosure may change, but the point about disclosure is if the parameters of the case do not admit of anything but success for the claimant, you can have as much disclosure as you like, but it won't affect the parameters of the case in the claimant's favour. If not, not.
Yes, well, I respectfully, wholeheartedly agree, and disclosure only matters if it goes to an issue which the judge didn't accept in favour of the defendant.
I mean, I have no doubt, if it's any help to you, that the facts of this long relationship are likely to be highly complex and very unknown at this stage, quite obviously.
Well, the short point is that the judge took the defendant's case at its highest.
That's the short point.
That's the short point. And nothing that the learned friend took it to can change that.
I mean, what he's got to get is, as I always call it, his screwdriver into the judge's judgment. So, to show that the critical paragraphs, which are really in the 120s, were wrong. He hasn't suggested that law was wrong, apart from the question on justification versus necessity. But he has to show that the approach the judge took to the rebuttal, effectively, of the People article was wrong. And if it was, you lose, Mr. Rushbrook. But you've dealt with all that.
And it's all on the premise that the defendant's case was taken at its highest. in relation to the pleaded case. Lord, I think I've covered all the points that I wanted to. I'm conscious that the goalposts have slightly moved in terms of the complaints about errors of law. Mr. Caldecott helpfully provided to us yesterday a 1.5-page list of alleged errors. If I've missed any, might I put in a short written rebuttal of the complaint?
I mean, I'd much rather you didn't.
Okay. Well, I don't think I have, but
I would take instructions, whilst I imagine Mr. Mill will be addressing us very briefly on the subject of copyright.
well, I'm content to deal with it on that basis. The only thing I think I need just to clarify is that the respondent's notice, which no attention has been paid to,
No.
doesn't need any attention, because nearly all of the pleaded contentions that we were saying the judge actually should have held had no real prospect of success. Nearly all of those have now gone from the defence, and I think, being realistic, the outcome of this appeal is not going to turn upon the question of whether what's left, having regard to the new draft re-amended defence, is viable or not. I mean, that's not really what matters in this appeal. So I don't think I need to say anything more about it.
Well, I mean, the new draft re-amended, whatever, amended defence seems to me to have no status before this court. Very interesting, I'm sure, and if we had endless time, no doubt we'd read it very carefully. But as it seems to me, it's not put front and centre of Mr. Caldecott's argument.
Well, and on that basis, beyond noting that nearly all of those contentions have gone from the defence in the respondent's notice, I don't propose to say anything more about it. So, any further questions I can assist you with?
Thank you very much, Mr. Basham. Yes, Mr. Mill.
1 second. Lords, my lady, I fully intend to adopt the invitation from the learned Master of the Rolls to be brief. I do so for 2 reasons. Firstly, because that is the way I tend to do my advocacy. And secondly, because there isn't really a great deal to be said, that needs to be said, in response to the summary judgment on the copyright issues. I have it under 6 topics. I won't even tell you what the 6 topics are, I will just address them in turn. The first is headed the copyright in the electronic draft. My lords, my lady, the defendant seeks to distort the character and content of that draft. It does so in order to suggest that the use of its content was not a weighty matter when balancing conflicting rights. The submissions made by my learned friend Mr. Speck are wrong in 3 material respects. Firstly, it is quite wrong simply to characterise the electronic draft and the letter as being a short factual narrative. My lord, the Master of the Rolls himself referred to it as a carefully crafted document, and there are a number of passages in the learned judge's judgment where he quite rightly describes the letter in terms which go way beyond a factual narrative. The court has, of course, read the draft and the letter carefully, and I don't need to draw attention to passages in it specifically to make this point. But can I just give you the paragraphs in the learned judge's judgment where he addresses it? They are in paragraph 73, in paragraph 76.1, 76.2, and then in conclusory fashion, which I will return to, 148. The court was also referred just now by my learned friend to passages in the re-amended reply of my client, which make it clear that the work that was done over a considerable period of time. the particular reference in that document is paragraph 12.7a.5. The second point is that learned friends suggest that in some way, because there is factual content contained within the document, that is relevant by way of diminishing the value and the weight of the copyright. And he suggests that because all that is left in terms of intellectual creativity is the choice of words used. When those responsible for granting Sir Winston Churchill the Nobel Prize in Literature because of his mastery of historical and biographical description, they were recognizing that which is fairly obvious, which is that the extent and the value and the weight of the copyright depends on the mode of expression just as much as anything else, and is perfectly capable of being substantial and weighty. I'm not suggesting that the electronic draft and the letter are Shakespearean in their quality, but nonetheless they show some considerable effort, but beyond effort, use of colourful and specific language meticulously put together. There is no reason not to give that full weight. And to the extent that one always listens with care to Mr. Speck when he seeks to educate the court on the law of copyright, one observes that even Homer can nod, and on this occasion, in relation to this point, he most certainly has. The third point is a point which I do invite the court's attention to, in particular. Where you have a factual piece of writing, that is to say, a piece of writing which takes on board events which have occurred, the property right which is submitted is particularly weighty when set against an Article 10 right. Because in the normal way, the person who is reproducing the contents can reproduce the underlying factual material and thus uphold the Article 10 right without encroaching on the property right. Is that a point which the court understands? I hope so, but it is an important point. I'll come back to it and illustrate it in the context of my submission on the balancing exercise in due course, but I do at this stage commend that point to the court. Second heading is the alleged failure of the judge to assess the weight to attach to the copyright and its infringement for the purposes of the defences with which this appeal is concerned. That is simply wrong. And can I illustrate that in the following way? Firstly, and to do so by reference to the judgment, which is probably a useful starting place to go. And paragraph 139. Under the heading of originalities, page 159 in the bundle, the learned judge said, this is by common sense a key issue. In principle, the questions of whether and to what extent a work is original are relevant to the subsistence of copyright and to issues of infringement. Whether more than one person takes part in the creation, the degree of originality of different parts may have a bearing on the question of ownership. Again, the nature and degree of the originality involved in a work can affect the availability of defences such as fair dealing, public interest, and if this is separate, freedom of expression. So the starting point is that the learned judge fully recognised the issue which it is said he ignored. And that is not, given that he expressly set it out in paragraph 139 of his judgment shortly before he dealt with those very issues of defences, is not a very promising starting point for the submission that my learned friend made. And when, my lords, in paragraph 148, he concluded that paragraph in the way that I will read out now. He's then talking about the contents of the electronic draft and the letter. He says they are much more than a short and banal insult. They comprise a long-form telling of, selecting a variety of literary forms interwoven with the narrative I've just discussed. The document expresses the exercise of expressive choice. The fact that the literary form is novel and interesting with a personal stamp appears to be reflected in the the way the defendant chose to deploy it so extensively. That, if I may respectfully say so, is precisely what he was doing, and which he is criticised for not doing, which is assessing the weight to be given to the copyright. And what he then goes on to say at paragraph 155, under the heading of fair dealing, halfway down, is the defendant copied a large and important proportion of the work's original literary content. The use involved an infringement of the claimant's privacy rights and was, with the modest exception I've identified, irrelevant to any legitimate reporting purpose and disproportionate. So what he has done with respect is completely unimpeachable. He's established the issue, he's considered the weight to attach to the copyright, and then he's determined the extent to which it's been infringed. That is precisely what he was obliged to do, and it is what he has done. Third heading, Re-S and Ashdown. The learned judge is criticised for not having referred to or relied upon the principles in Re-S. Could you please turn to tab 14 in the bundle, core bundle 1. This is the learned judge's reasons for refusing permission to appeal to this court. And you will see at the bottom of 197 under the heading copyright infringement, the learned friend, Mr. Speck, made submissions to him focused on two particular submissions.
So which page is it?
I'm so sorry, my lord, 197?
Yeah.
The second of those is that his approach to the Article 10 defence gave it too narrow a scope and treated competing rights as having greater weight, thereby contravening the principles in Re-S. What he says about that over leaf at paragraph 8 is as follows. As for the principles in Re-S established 17 years ago, I suspect I may have cited these more often than any other judge at first instance. They are so well embedded in the jurisprudence, it's hardly necessary to reiterate them. But I did so in this case, albeit via citation of my recent judgment in Sikri and the Court of Appeal decision in ZXC at 105. This ground appears to rest on a misplaced semantic analysis which cannot be sustained when what I said is read properly in context. In particular, the suggestions that I treated property rights as weightier than freedom of expression or treated the effect of Article 10 as substantially covered by the fair dealing defence are, in my view, untenable. For your Lordship's note, the reference that the learned judge makes there to his judgment referring to Sikri and to ZXC is to paragraph 29 of the judgment. So that's the first point. He had Re-S well in mind. Secondly, my learned friend refers to Cartier. It says, yes, well, Mr. Justice Arnold, on the facts of that case, referred to Re-S, he didn't refer to Ashdown. So what? I don't know whether Ashdown was cited to the learned judge on the facts of that case, but those facts of that case were so completely different from this one. It was a completely one-sided case. There was nothing to weigh against the property right, because these were people who were infringing trademarks in a wholesale fashion, and they had no rights to be protected. In any event, so what? I don't understand my learned friend to be saying that Ashdown is wrong or has been overturned. It's clearly a relevant case to look at in the context which deserves it, which this case did, as I will come on to show. The next point is to explain the context in which we rely upon Ashdown. We don't rely upon Ashdown, nor did we before the judge.
This is not your fourth heading. This is
all part of the Re-S Ashdown.
Yes.
But this is 3 part 2.
The context.
The context in which we refer to Ashdown is for the general principles that are to be derived, not for a submission that, given the facts of this case and given the decision in Ashdown, the court was inevitably bound to find in our favour. Now, I'm going to come back to the principles later on under heading 5, but I just make that point at this point. I should, however, say one thing about my learned friend's attempt to distinguish Ashdown from this case. He says that it's a case that is to be distinguished because that case was all about authenticity. I wonder if we could look at the re-amended defence in this case, just to see how the issue arises here. And that is tab 21, so I think core bundle 2. And could you turn within that, please, to page 345? Actually, perhaps, probably to get in its proper context, we could turn, I'm so sorry, to page 362 and 3. Paragraph 36, to which my friend took you, is the plea in relation to Mr. Markle's rights under Article 10. And there are particulars set out below that. And then 37 on the next page is the reference to fair dealing. And your lordships, my lady, will see that under 36.1 and under 37, there are reference to the identical paragraphs of the defence. Those include 15 to 1516. And if you go back page 345, we see paragraph 1514, which is the way in which the defendant seeks to justify the use of the text of the letter as opposed to a descriptor of its content. The identification of the words complained of by the claimant in Appendix A to the response confirms that the claimant does not allege that it was unlawful for the defendant to publish an article referring to the fact that the claimant sent the letter to her father, that her father was upset by the contents of the letter, and that he had written a letter to the claimant in response from which quotes are set out. The parts of the article setting out these matters are not complained of. It was a matter of editorial discretion and judgment to illustrate such an admittedly lawful article with extracts from the letter, to give the article conviction and to engage the attention of readers. Now, as I understand it, my lords, that taken together with Mr. Verity's witness statement, when they're talking about giving the article conviction, that's the authenticity point. The only other matter that they rely upon to justify the use of the text of the letter is to engage the attention of readers. And in that context, I do invite you to look at what was said by the Court of Appeal in Ashdown, as I believe, paragraph 82. So that's tab 15 in the first authority bundle. Paragraph 82, it says as follows: there may in law have been justification for the publication of the confidential information that was contained in the minute. That is not an issue which is before this court. We do not, however, consider it arguable there was any justification for the extent of the reproduction of Mr. Ashdown's own words. It appears to us that the minute was deliberately filleted in order to extract colourful passages that were most likely to add flavour to the article and thus to appeal to the readership of the newspaper. Mr. Ashdown's work was deployed in the way that it was for reasons that were essentially journalistic in furtherance of the commercial interests of the Telegraph Group. We do not consider it arguable that Article 10 requires the Telegraph Group should be able to profit from this use of Mr. Ashdown's copyright without paying compensation. And the reference there to journalistic considerations is effectively precisely what is said in 1514, where it said it was a matter of editorial discretion and judgment. So although I don't rely upon Ashdown as saying the facts of that case mean we have to mean on this case, nonetheless, it is to be noted that the Court of Appeal specifically deprecated the idea that it could be fair dealing to use the precise text essentially to generate money for the defendant, which is, to be clear, precisely what we say, and it appears they admit was done in this case. That's my third heading. My fourth heading is balance. Now, my lords, my lady, I listened with care to what the learned Master of the Rolls said yesterday to Mr. Speck. Effectively, well, if you win on the privacy case, then you're bound to win. I think your lordship said bound to win on ground 8 and probably ground 9 will follow as well. May I, with the greatest of respect, seek to persuade your lordship otherwise?
Of course.
Thank you, I'm much obliged. My lords, the basis upon which, as I understand it, it was being suggested that we could not win if we lost the privacy case is because it would follow that Mr. Justice Warby conducted the wrong balancing exercise because he, for example, didn't take into account all the matters that it was appropriate for Mr. Thomas Markle to respond to beyond the olive branch, par exemple. So be it. But what's that got to do with the text? This is the point that I was making at the outset about the weightier nature of the property right where you're dealing with factual piece of writing. It was totally open to Mr. Markle, to the Mail on Sunday, to describe the content of the letter to a greater extent than the learned judge said was appropriate, but without using the text. So with the greatest respect, the first point is it by no means follows that if we lose on the privacy claim, we lose on the copyright claim. Quite the contrary, because unless your lordships can conclude that it must follow that Mr. Markle and the defendant were entitled to use the text to a greater extent than Mr. Justice Warby said was permissible, then nothing else follows from it. That's the first point. The second point is this. Why have a trial, even if your lordships are right, and my lady is right on that? What? I hear all the suggestion of this being a triable issue and having to go to... What facts? What facts? I have not heard a single fact, triable fact, on the other side, would need to be taken to trial or need to be established at a trial in order for that evaluation, that rebalancing exercise to be carried out. And your lordships are, with the greatest respect, required by the jurisprudence on summary judgment applications such as this to determine issues. And let's look at the language. It's in the learned judge's judgment at the outset. This is a quotation from Easier.
I'm not sure we need it except for forensic flourish, Mr. Moore.
I'm sorry, my lord.
I don't think we need easy air except for forensic flourish. You're saying we should grasp the nettle if there is no reason not to.
Yes, there's no not to, and there's no reason not to unless you are prepared to accept that there is material which may come out which is germane to the outcome of the case at a trial. So, you're right, I don't need to take it there, but your lordship, I hope, has the submission.
I mean, when you said that I had said to Mr. Speck that if he won the privacy case, he'd win the copyright case, I might have said to you that if you won the privacy case, you'd probably win the copyright case for precisely the same reasons.
And I would have said, your lordship is wrong about that, but I win it for the reasons that I say we win the copyright case, not for your lordship's reasons.
Well, for the reasons the judge gave.
For the reasons the judge gave, because he was clearly correct.
Yeah.
For the reasons that I hope I'm helpfully giving to the court this morning.
Fifth point.
My lord, yes. Actually, I just wanted to say one other thing on that point about the use of the text. Mr. Markle, it was, who said that he wanted to be able to comment on the tone and content of the letter. It's referred to by the learned judge in paragraph 52 of his judgment. And that expression, tone and content, is one that was all over my learned friend's submissions to you, both from Mr. Caldecott and in particular from Mr. Speck. And it is that which can be the only basis upon which they say it is appropriate to be able to refer to the text. You can describe the tone and the content of the letter, without the need to show the text. So when your lordships, if your lordships are driven to it, decide that they have to carry out a fresh evaluation, the court will, with respect, I hope, take into account the points I have made, together with the fact that this letter was unpublished. My learned friend, Mr. Speck, just said, oh, well, there is that factor, it's unpublished. As is quite clear from the passage in Laddie, which everyone has accepted, sets out the position correctly. That is a hugely significant matter. And what that passage in Laddie says, which is cited by the judge in his judgment, is that ordinarily that's going to be the end of the matter. How can the Article 10 right outweigh in those circumstances? Lords, Mr. Speck at one point, I think this follows under the same heading, Mr. Speck at one point suggested that sometimes, effectively, more may be less. In other words, the more you quote, the less, or the more fair, or less unfair, the dealing is. Well, that's jolly interesting as a proposition, but how does he apply that to the current case? As I understand it, he wishes to do that by reference to material that's not before the court, to do with draft amendments to the pleadings and new evidence. And having taken, I will take the approach that the court invites me to adopt, and therefore I'm not even going to respond to that. But what we've got here is an extraordinary amount of reproduction. Just to give you some idea of it, the judgment of paragraph 56.
It's just over half, isn't it, Mr. Mill?
Well, Lord, it's actually just under half.
Just under half.
I'll give you the
About
reference for that, but can I just give you 56? The minimum number of repetitions was 1, and the maximum number was 12. Taken together, the articles contained 88 separate instances of quotation from the letter. And I think the 47%, your Lordship may have got that from our skeleton below, which is in the supplemental bundle at tab 16. And the page is 160. I think that's a false reference. Just bear with me a moment. I'm so sorry, it's 187. So paragraph 161, you will see how that 88 quotes is split up. 16 quotes in Article 1, 14 in Article 2, 17 in Article 3, 23 in Article 4, and no fewer than 18 in that ridiculous article about the handwriting. Sorry? 150 of the... Thank you. And what we say there is that Articles 1 and 2 contain different quotes numbering 15 and 14 respectively in total. Articles 3 and 4 and 5 repeat the quotes from Articles 1 and 2. The total of almost 50% of the content of the letter is reproduced at least once in the articles. And I should just also, finally, on that point, draw your attention to 150 in the judgment. Where it is said that the letter as a whole ran to 1,250 words, of which the male articles reproduced 585. And the approach taken below by the defendants in relation to the handwriting article which as I understand it is still maintained here, is that the court shouldn't look at that independently. You should look at it cumulatively as part of the overall picture when deciding whether fair dealing has been undertaken. I will be corrected if that's no longer their position, but it was expressly in writing before the learned judge below. Well, so be it. In that case, I'm entitled to rely upon the handwriting article as being the clearest possible indication that overall this was not fair dealing or one where the balance is in favour of the defendant, because there cannot be any sensible explanation for that consistent with an enforcement of an Article 10 right or fair dealing with the article. That's 4. The next is the judge's reason for rejecting Article 10. So, what Mr. Speck said in his submissions to you yesterday is that the judge is wrong in saying that the grounds relied upon for free speech and fair dealing are not materially different. Of course, it's true that the underlying factual narrative, the specific paragraphs referred to earlier in the pleading, the actual grounds differ significantly, not least Thomas Markle's reliance on his free speech rights. So I think it's relevant in that context, first of all, to look to see what the learned judge said, and then to look at the pleading. So the learned judge, in deciding the Article 10 aspect of the case, referred to Ashdown, and I'll come back to Ashdown in a moment if I may, in 157. And then in 158 he said, in my judgment, this is not one of the rare cases referred to in Ashdown. There is no basis on which the court could conclude that although the copying of the work was not over fair dealing for news reporting purposes, the public interest requires the copyright to be overridden. That's his conclusion. Then what he says is that the reasons for that conclusion, are sufficiently explained by what I've said already, because the grounds relied upon to justify the public interest are not materially different from those advanced in support of the fair dealing defence. And what my learned friend said to you yesterday is, well, if you look at the pleading in relation to fair dealing and freedom of expression, then they are materially different. Well, we don't accept that. So I need to take you to the relevant parts of the defence in order to make my submission good on that. So it's page 362 in Core Bundle 2. Paragraph 36 deals with the Article 10 claim. As I've indicated, the paragraphs that are relied upon in 36.1 are identical to those relied upon in 37. What my learned friend points to is paragraph 36.2 as being entirely separate from what's under paragraph 37. And your lordships and my lady can read paragraph 36.2 to themselves. But if you then go and read that and set that against what's in 37, below the passage which deals with the paragraphs that are relied upon, it is essentially the same point, albeit expressed in a slightly different way. The claimant's relationship with, estrangement from, and her conduct towards her father were accordingly all particularly current and placed in or raised in profile in the news agenda by the claimant's own actions. Yet further, Mr. Markle's reaction to and view of the letter and the people interviewed were current events the legitimate subject of news reporting. In particular, his dispute with the version put in the public domain by the claimant's own actions and contradiction of and dispute with the version of the claimant's conduct towards him was also a current event, the legitimate subject of news reporting. So it may not be expressed in quite the same way, but the substance of it is the same. In any event, my lords, it's quite clear why the learned judge refused to allow the Article 10 defence. He did it for the reasons that he'd given in relation to fair dealing. And that was because, self-evidently, the use that was made was excessive and not fair. And when viewed in the light of his conclusion earlier on, that the only passage that it was permissible for the letter, the only passage in the letter that it was permissible for the Mail to publish was what he terms his paragraph 15. It's quite obvious why he would have reached the conclusions that he did. In any event, finally,
which of course is the same reasons as the privacy claim is rejected.
Indeed, I accept that, but not the consequence that your lordship is inviting me to accept flows from it.
Of course. We all have to have a reason for being here.
So true. My lord, I was then just going to draw attention to what Ashdown says, but your lordship has been taken to Ashdown. Can I just remind you of the paragraphs which set out points of general principle?
Yeah.
For your lordship's note, ladies' note, paragraphs 31, 39 to 45, and 66. And could you particularly note in 45, the way in which it's put in that paragraph is entirely consistent with Ries. Finally, and I note the time, and I can do this in 1 minute, pro sebum, the last point that was made by Mr. Speck after the luncheon adjournment yesterday. As I understand his point on pro sebum, it's that the learned judge, contrary to the approach in pro sebum, allied together the question of purpose and fairness. Well, it's self-evident from the judgment that he didn't. If you look at paragraph 156, he said in 2 sentences at the bottom of that page, it was essentially for the purpose of reporting the contents of the letter, which was not a current event, and the use made was not fair. I mean, how clear does the learned judge need to be? He clearly wasn't eliding it. He was making 2 points. The point that my learned friend is really making, which gets him nowhere, is that the judge was wrong in his approach to what purpose meant, for the purpose of that part of the exercise. The reason why he didn't put it that way is because, of course, that gets him nowhere on this appeal, unless he can establish that the judge was also wrong in saying that the use made was not fair. So, my lords, I have, I hope, been brief. I would obviously be happy to answer questions, but subject to that and anything from my learned junior behind me, those are my submissions.
Well, you've been commendably brief, Mr. Mill, and we're grateful for that. Thank you. But I think we'll break now. I'm afraid to say that Milady and I have another engagement over lunchtime, which will detain us until, I guess, 2:10. So I'm going to say not before 2:05, just in case we manage to get back at breakneck speed. Unfortunately, it involves changing into more exotic robes, and that takes a little time. At 2:05.
Daddy would be happy. I think Daddy would be happy.
We love it. Really well.
I had him fully in mind.